Do you want Then they say you to pay. Okay, I can take it.
So then you pay.
But then you can
The travel inside. Hey.
Then you have to drink.
You can't.
But now the other thing they don't love. It's tomorrow before proceedings. Yes, there was one. Haikuwa nayo milioni ile kwanza. Haikuwa nayo. Niteke. Hello? 5 shillings. Poa. Wakili wa nini? Anakuja kusema nini? But why are they entertaining those things? Anakuanga mjini. Momani ya kurada.
Who has the access? The other thing is that when who has the so that the person who the category avoid the access, it is opposed to the elections.
Yes, sir. Yes. We already gave instructions. Yes, I know.
All of them. We must. We must.
I'll need tomorrow.
So we must. Some of them after every case, evidence came that there was massively high protest. when you were just at the point of now closing. The issue is that when there is evidence of and the court accepts and the court accepts the mention that I'm posting my server this server is the one that is It's really because that is where I was reading. So some of the elements we have the sample that in the reach of the codes within the reach of the code situation. That's what they say they are so that it means there is an interface between the IBC and the travel persons. But again, but if you go to the Foundation Act, there is no that link. That link is not a link. So we must create the link between the IBC and the office of the registrar of persons. We must synchronize it. They never do it. Number two, we also need to say, like the way we are saying we are going to review our constituencies after every 5 years or 10 years or 8 years. Even the register must be politically reviewed. As we review the boundaries, we also review the register politically. So that we are not then saying, whenever we need to review it, we must synchronize the review of the register, the review of the boundaries. How we do it. So they have to be registered again in that. Why can't you have to fresh? The register. Yes. No, not anywhere. We are refreshing as we refresh the boundaries. We objected. We make this place a government.
So when you want one time, that's all when you want time.
Never one time.
So we are going to
which is a right thing for the nation. So that the constituents can also here, also here, to the limits we are refusing. So if we don't review the material at that time, it will affect the question of the because there will be people, yes, there will be people who are not represented. Yes, there is an MP there. Like what is happening? But in Illinois, they are who are not represented because they are beyond the population. So hiyo ndio hapa kuna watu ambao hawana elimu. So to avoid that, elections will happen in each and every constituency. So, and the contemplated constituency has undergone the process of modification and modification. So if you do not believe it, does it conform to the template?
Anaendelea yuko hapa.
It doesn't. It doesn't happen. And that's the
Na nishakwambia.
First of all, I wish to more sincerely apologize that I did at 11. It was 1 hour late. So my sincere apologies. So we can get the scorer. So let me ask for number 382 of 2025. James Jerry or James Kihara.
Ewanjiro is going to brief for Mother Karua. She's a general study brief for Mother Karua. Manzo is holding brief for Alonso Misioka. Daniel Amalemba is for the accused.
Present, Your Honor.
Sosia Kihara has appearing.
Good morning, everyone. For the state, my name is Mo. Together with Miss Sonia, we are ready for the reading.
So last time I requested for those authorities that were cited that is neither of them, or neither side of the eye, actually submitted, but I was able to capture the same authorities. I think nowadays it's so easy to get those authorities. So then I'll proceed with the ruling. So Jane Jerry Kihara, hearing after I refer to her as a suspect, was arraigned in court on this on the 18th day of July 2025 to take plea on the offense of offensive conduct conducive to breach of peace under section 94, subsection 1 of the Penal Code. The particulars thereof has been successively set out that on the 8th day of July 2025 at Nairobi City, within Nairobi County, being in a public gathering, uttered words to read, open quote, I want to talk about Naivasha because I know those goods were transported in NYS bus in a place called Karangita. They were dropped there. In town, they were brought in trucks in my mind. So all these people, nobody knew them. As I condole with the bereaved and also empathize with those whose properties were distracted, I want to tell President Ruto, this is not a war. You can win unless you want to destroy this country. It is about the youth. It's about young people who you went around promising heaven, and what you are doing now is digging deep so that they go under. It did not happen. In Naivasha, they killed one, 3 in critical condition, and as my colleagues have said, police are doing anything. They didn't try to arrest the goons. They're not doing anything. They didn't try to arrest the goons. You can see in the place who's working with them. So it is not anything that is going to end. We as Kenyans are prepared to prepare our country so that you cannot. We as Kenyans are prepared to prepare our country so that you cannot be drowned by one single person because you think you're so powerful, yet you have the power which we give you. You cannot use the same power to destroy us and destroy the country. End of quote. I'm quoting verbatim. With intent to provoke breach of peace. So I take judicial notice that the suspect is the sitting and current member of parliament representing Naivasha constituency. The suspect was represented by a battery of council. They were led by Dr. Kalonzo Musyoka, Senior Counsel, Mr. Muturi, Mr. Kihara, Mr. Kirabu, Mr. Ndego Njiru, Mr. Weregi, Mr. Malemba, Mr. Nyambu, Mr. Wabugu Wabujohi, Mr. Mageto, et al. So the state, on the other hand, was represented by Ms. Nora, Mr. Witi JB, Ms. Sonia, and Mr. Momani. So in its application, canvassed orally on the 18th day of July 2022, counsel for the suspect have vigorously opposed the suspect from taking plea. So that is the canon and quintessence that this court is called upon to make a determination on. Dr. Musyoka, Senior Counsel, has urged that on the casual glance of the charge sheet, the suspect is charged with the offense of offensive conduct under section 94, subsection 1 of the Penal Code. Senior Counsel adjured that this is purely political persecution and that the alleged utterances falls within the constitutional realm and orbit of freedom of expression and press, and furthermore, the particular does not disclose any offense. He poignantly supplicated that other people or politicians have said worse statements, thereby ignoring selective and or discriminating prosecution. Senior Counsel was appalled by how the arrest was conducted in terms of the public resources used and the numerical force that was used against the backlog of the misdemeanor charges that now the accused has been arraigned. And therefore, he espoused that the acts by the enforcement agency were all unconstitutional. On his part, Mr. Kihara stated particulars of the offense as well do not disclose the ingredients and were unconstitutional. He submitted that being a member of parliament, the suspect was a mouthpiece of our constituents, and which she exercised by dint of Article 33 of the Constitution. Mr. Ndegonjiru guarded this court on the enforceability of rights within the refraction of the constitutional imperative and the dictum vis-a-vis the statutory provisions and the doctrine of statutory decisis. He entreated that pursuant to Section 8.1 of the Magistrates Court Act, this court is clothed with the jurisdiction to hear and determine applications for redress of a denial, violation, or infringement of, or threat to, a right or fundamental freedom in the Bill of Rights. We thus urge the court to invoke Article 33 of the Constitution in delineating whether the charge sheet borders on a threat to a right or violation of fundamental principles. Further, Learned Counsel Mr. Njuru, our most stringent argument is that the statutory provisions must be symmetrical and harmonious with the Constitution by dint of Section 7 of the 6th Schedule and Article 10 of the Constitution on national values and principles of governance. He thus avowed that this court has the jurisdiction in entertaining the instant application relating to the threat, the denial or violation of the suspect rights in the constitutional review of Article 33 of the Constitution on the freedom of expression as juxtaposed with the Section 94.1 of the Penal Code. He expressed further that the particulars do not disclose an offense for the suspect to comprehend to the charges she is facing. Counsel further argued on the limitation of rights and fundamental freedoms under Article 24 of the Constitution, submitting that rights or fundamental freedom cannot be limited only to the extent that the limitation is reasonable, justifiable in an open, democratic, and civilized society. Counsel also made reference to Article 19, 20, and 27 of the Constitution. On this part, Mr. Kihara extensively submitted on the composite of the offense that the suspect is facing, basically urging that the three ingredients to the offense has not been disclosed sufficiently. Concomitantly offending Article 52B of the Constitution. The Learned Counsel, Mr. Wambuku Wanjoy, iterated that the charges were not warranted since no clear offensive conduct had been identified, with the charge sheet being broad, vague, and ambiguous. He adjured that Section 94 of the Penal Code criminalizes conduct and not political opinion or opinions, with no nexus between the words alleged uttered with the breach of peace. Conversely, on behalf of the state, Mr. Witty vehemently opposed and backed the application. He unerringly submitted that jurisdiction is everything, reverberating the old aphorism that a court of law down its tools in respect to or matter before it. He reverberated the old aphorism that a court of law down its tools in respect of the matter before it the moment it holds the opinion that is without jurisdiction. On the jurisdictional question of Section 881 of the Magistrates Court Act, Learned Counsel argued that under Section 828, Section 2 of the said Act, this court's jurisdiction is stemmed and hamstrung to rights under Article 25A and B of the Constitution. Corollary, excluding Article 10, 19, 20, 27, and 33 of the Constitution. He further argued that Section 94.1 of the Penal Code is in force and it applicable in collocation to Section 7 of the 6th Schedule of the Constitution. He exhorted that pursuant to the Article 2, Article 2, Article 2, sub-article 2 of the Constitution of this court has no powers to legislate. Learned counsel further is the witness submitted that the relevant law governing the framing of charge sheets are found under section 89, 134, 135, 136, and 137 of the Criminal Procedure Code. He argued that the charge sheet presented encapsulated the statement of offense and the particulars sufficient to be understood by the suspect. He enjoined that at this stage there is no need to prove any ingredient, each of the ingredients, since the court will be falling into a danger of conducting a mini trial. He beseeched that the ingredients ought to be established during the main trial. So he relied on two authorities, the Kuldeep Madan and another versus Director of Public Prosecution, as well as Hussein Khalid and 16 others. So decision from the foregoing, two issues arises for determination, namely, jurisdiction to enforce the Bill of Rights by the magistrate courts. Secondly, the competence of the charge sheet. So on the question of jurisdiction, I'll start off with the Supreme Court case, Supreme Court of Kenya in application number 2 of 2011, involving Samuel Kamau Macharia versus KCB and others, 2012 EKLR, which the court held, and a court's jurisdiction flows from either the Constitution or legislation or both. Thus, a court can only exercise jurisdiction as conferred by the Constitution or other written law. It cannot arrogate to itself jurisdiction exceeding that which is conferred upon it by law. The court must operate within the constitutional limits. It cannot expand jurisdiction through judicial craft or innovation. End of quote. I'll also cite the famous case of owners of motor vessel, William S. versus Perfect Oil Kenya Limited, 1989, EKLR, where I'm sure all of us are familiar with this authority, so I'll not read it. So as aptly stated by both parties, the jurisdiction of the magistrate court in dealing with the enforcement of the Bill of Rights has since been addressed by Section 8 of the Magistrates Court Act. The parameters, despite being explicitly stated under Section 8, Subsection 2 of the Act, has also found fortification in the Supreme Court decision of Hussein Khalid, which I've quoted before, during above, where the apex court, whose decision is binding before this court, enunciated thus, and I quote, Parliament has granted to the magistrate courts powers to consider applications on alleged violation of the Bill of Rights, but has limited the power to only two rights under Article 25A and B. And that, according to the apex court, is that one is for the freedom from torture, cruel, inhuman, or degrading treatment or punishment, and also the freedom from slavery or servitude. I proceed to quote the apex court. This limitation is constitutional, as Parliament does not bar a person from bringing a case alleging violation of his rights, but only limits the forum where that cause can be done. They have cited this was captured by the High Court of Australia. I'm not going to those, you can have it once you have this ruling. So I'll share with you so you have a look at it. So, well, from the foregoing, it is crystal clear and need not be belabored further that this court can only enforce rights that fall within Article 25A and 25 subsection B, paragraph 6 of the Constitution. Therefore, on the elemental question of jurisdiction, I'll down by 2. So I go to the second question for determination, and that is of the competence of the charge sheet. So the first port of call is on the mandate of the DPP. The office of the DPP is an independent constitutional office which is not subject to the control, direction, and influence of any other person. Under Article 157, Sub-Article 10, and Section 6 of the Act, the DPP shall not require the consent of any person or authority for the commencement of criminal proceedings, and the exercise of its powers or functions shall only be under the direction or control, or shall not be under the direction or control of any other person or authority. The independence of that office is, however, not absolute. Article 157, sub-article 11 requires that the holder of such office to have regard to public interest, the interest of the administration of justice, and the need to prevent and avoid abuse of the legal process in exercising the powers conferred by the Constitution and the Act. So, based on the foregoing, it follows that the DPP can present charges within the confines of the law. The question for settlement now is whether, and which is paramount, is whether the charge sheet against the suspect is competent. So there are plethora of authorities on question of the competence of framing of charge sheet. So I'll not go into that. I'll go into section 134 of the Criminal Procedure Code that states, and I quote, every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense. End of quote. I'm not going to read section 176. I've elaborated the provision of that section 176, 137. So courts, as I've stated, has also considered what is essential in framing of a charge. In the often cited case, in the realm of framing of charges, the case of Sikilani versus Republic, 2004, 2 KLR, 480, I'll not cite that. What the court stated. So further, the Court of Appeal in Nyamai Musyoka versus Republic 2014 also expressed itself on the test whether charge sheet is fatally defective or incompetent. I will not cite it. So indubitably, therefore, a charge must therefore be clear and easy to understand. In as far as possible, the use of technical language in a charge sheet ought to be avoided. An accused person must be accorded an opportunity to understand what he or she is facing before court. I've cited the authority of Besman Katwenge Wafula versus DPP, that is petition number 045. So I'll go to the finality of the finding of the court. So in Incitement, I find that the requirements of a properly drafted charge sheet has been surmounted by the state. I find also on the face of the charge sheet, I'm of the conscientious view that the suspect will be able to fathom and adequately discern and be able to prepare for her defense. So the finding of this court is that I'll direct the suspect to take leave in respect to the charge sheet that has been presented before court.
Yes, Your Honor. We have recent hearing and we are well guided in regard to a number of issues that you have raised, and others will appreciate that we read the full text of the ruling. However, the defense, if you like, make an application to defer the taking of the plea today. Yes, to enable the defense team to get the views of the Constitutional Court. On a number of issues, Your Honor, we need not be emphasized in this. We argued last time. Still, with the suspect still holding her gun, because he's entitled under the Bill of Rights not to say anything to the charges, to confirm whether she had statements or not. To make a reference so that the Constitutional Court is in a position to define the parameters of the constitutional privilege in the license of a member of parliament. When you are addressing your constituents, grave issues as a breakdown of law and order. There have been property destroyed. Lives have been lost. And I think a number of issues are very clear, even from the ruling, that she's a member of parliament, that is not in contention, that she takes a much wider license in terms of her freedom of expression at that degree, as read together with the parliamentary statutes and the separation of power doctrine. I'll have my colleagues here assist further, but the only thing I may mention, so that we ask you for a short time limit. We propose 14 days to be able to go to move the Constitutional Court. We have to appreciate that we are also going on vacation, but so we may not be sure whether we will get a date as fast as possible. The only thing I may mention is that we need to seal this license in terms of even a judicial officer. Tomorrow could be arraigned on the basis of a judicial decision or a statement made in court. I do think that you think it's far-fetched, but we are living in very uncertain times. And I think it's good to mention that, so that we appreciate the doctrine of separation of powers and the license that goes with that office of a member of parliament in regards to our constituents' issues involving security.
Allow me just one or two.
Thank you, my other friend, Mr.
I think what you can agree how many?
Yes.
Purposes of order.
Yes.
But if you have an advantage of going through my ruling,
Yes.
even in a bit I have indicated the manner and the mode of arrest.
Yes.
I have castigated the agency for the way the arrest was done.
Yes.
So it's holistic. On the question of, and I've explained to the Supreme Court, I've cited that case of
Yes.
on section 33, in as much as I would be really wanting or urging to make such determination, but my hands are tied.
Yes.
We are appreciating that.
Yes, you actually want to address why your hands are not tied.
Yes.
And at the fullness of time, you grant us the stay. And the High Court will be able to set that record clear. I am of the convinced opinion that your hands are not tied and that Section 8 does not limit you. And that is why you honor the justification for the stay. But let my learned friends add.
So how many of you will allow me?
We are only the four of us. So if Mr. Muriu goes first, then my learned friend goes, then I'll sum up.
Thank you. With the utmost respect, Your Honor, we are dealing with an extremely fundamental issue touching on Article 33, the freedom of speech. Going by your dissection, both under the Constitution and the civil procedure, this matter is purely a Bill of Rights issue. therefore, it requires a controlled interpretation on what constitutes to a crime by a citizen of this republic, and also what constitutes a crime by an elected member of parliament. An elected member to represent people in various legislative bodies. Your Honor, this is informed by the fact that the role of an elected member is, number one, representation. Number two is legislation. And number three, Your Honor, is oversight. And therefore, when a member of parliament makes a statement on the state of affairs in his constituency, and then that statement is criminalized, Your Honor, I would say without any hesitation that if that's the case, we no longer have a country. And therefore, that's why I urge you kindly to allow us to have interpretation of the international court, and we defer the taking of the plea of the accused. Thank you, Your Honor.
Your Honor, your kind permission, my name is Mansa. Your Honor, we are pleading with the court that you give us a stay of your ruling for 14 days, and Your Honor, at the same time, stay the taking a plea, so that a very important constitutional matter can be explored, probably in a manner that has never been explored before. Your Honor, the reason is that these sort of charges have become very many recently, and the court needs to state its position squarely, which has not been done before. Otherwise, these courts are going to be flooded with similar cases, overload the court system unnecessarily, and even spend the public money wrongly on the part of prosecution and on the part of judiciary, pursuing cases which will end up in acquittal. And that's why we are pleading with you that you take your ruling, and you also suspend the charges so that we may squarely now go to the courts fully entitled to interpret those sections, and Your Honor, justice is important for the country. I thank you.
I fully associate myself with the submissions made by my line seniors and give you the justification why you ought to grant us an order of stay. This order of stay we are seeking, Your Honor, is akin to the orders granted by the Supreme Court of Appeal, the famous Rule 52B. And therefore, Your Honor, what we need to satisfy you with is whether or not there is a justification for that stay. It has been urged before Your Honor that the judgeship borders between violation of fundamental rights. Therefore, the question to answer is whether or not, if that charge is read and plea taken by the suspect, whether it will amount at the fullness of time to a violation. Whilst answering that test, Your Honor, we shall be answering the question of rendering the intended constitutional petition nugatory. If she takes plea and then we move tomorrow to the High Court or today to the High Court, will it be an academic exercise? Will it amount to an academic exercise? That is a test that will the court ought to apply. Number two, Your Honor, is a test that, granted the magnitude of the petition that we intend to file and the consequences that will befall the accused person if she were to be found to be guilty, would eventually culminate to a fine of 5,000 or 6 months imprisonment. That is to say, therefore, the violation may be much more surmounting than the consequences that will befall her. The other test is whether there shall be any person who shall suffer prejudice. And the state being the complainant, and in the absence of a private citizen who would fall in the category of a victim, the balance tilts in our favor. That there is no natural person saying that Honorable Jenny Kihara has wronged me in this way, and therefore the delay will occasion injustice to that particular person. Because this is an alleged offense against public order. The other justification, Your Honor, is that we need the High Court to expound on Section 8. And this is a justification, Your Honor, that Section 8 cannot limit you to the only rights under Article 25, A and B. Because A and B speaks about torture and being subjected to slavery and servitude. Yet today, or even when we appear before you, you exercised a right under Article 49. Article 49 is not what is encompassed under Section 8. Therefore, to say that Section 8 is constitutional would therefore mean that you today you not even have the ability of exercising the rights under Article 49. Because Article 49 is not covered under Section 8. It therefore means that all these courts have been acting unconstitutionally. Number two, Your Honor, while Article 25 speaks about the non-derogable rights, among them Article 50, the fair hearing is not encompassed, is not protected under Section 8. Does it therefore mean that this court will not, or any other magistrate court, cannot exercise that right under Article 50? Because Section 8 limits. The other justification, Your Honor, is that this court is enjoined by Article 10 to enforce the Bill of Rights. Article 10, which binds all state organs, state actors, state, whenever any of them is interpreting the law or applying the law, is not covered under Section 8. So the question will be put into the High Court is, can Article 10 give and Section 8 take away? So those are very fundamental issues that will settle the law on the ability of the Magistrates Court to enforce the Bill of Rights. Because Article 10, Your Honor, provides in a blanket way that you must enforce a Bill of Rights. And enforcing them is protecting them from denial, from infringement, from violation, or even from a threat. And therefore, to protect that foreseeable threat, the application for stay is justifiable. And it's not just justifiable, it's justicious. And Section 8, Your Honor, does not bar you from applying the doctrine of proportionality while granting this stay, insofar as the rights that we are seeking to protect are in issue. So, Your Honor, there is all reason to justify that one, the accused persons before you, or the suspect before you, is a state officer. What she's alleged to have violated relates to her constituency. There cannot be representation without speaking. That is, there cannot be representation without the right of self-expression or freedom of expression. The state says we have violated it. How then will representation ensue? So, by the stroke of the pen, Your Honor, it can, or by the action of the ODPP exercising their power under Article 157, can actually amount to a limitation of a right, and that is what you want to go and argue in the High Court. And we are not offended by your findings. We are offended by the legislation. That the legislation is purportedly limiting you to protect a right. 14 days, Your Honor, is not so much to ask. Honorable Jane Kihara will still be within the jurisdiction of this court. She will be available and she will be subject to you. So we can have a mention in 14 days to confirm the outcome of our proposed petition. If this, Your Honor, is not going to be done, you'll see a litany of members of parliament appearing before you. Even myself, I may appear before you, especially when I say one term. I'll be next. Especially when I propose a doctrine of one term, which you propose out there. So, Your Honor, or the member of parliament for Natanga. So, Your Honor, we urge you to grant us this stay, subject our arguments to those three tests: who suffers prejudice, whether the proceedings will be rendered nugatory, whether they will amount to academic exercise, and whether it is justicious for us to move to the High Court and check the possibility of Article 10 giving and Section 8 of the Rights Court taking. Thank you, Honor.
You know, we might be saying all that and the state is conceding.
We will come the concession.
I have a few comments. You know, as you have rightly stated in your ruling, the only issue for consideration here would be whether the charge sheet that we presented before you was proper under Section 134 of the CPC, whether it discloses a known or existing offense, and whether the suspect hearing will be able to defend herself or rather understand the charge well enough to put in a defense. And those questions have been answered in the affirmative by your ruling. Yona has also distinguished what pertains to freedom of expression under Article 33 and whether this court can deal with issues pertaining to limitation of some rights under the Bill of Rights, and as rightly stated by the court, and the authority that the court alluded to, the only violations that this court can entertain in line with Section 8 of the Magistrates Court Act are the ones under Article 25A and B. Yona, at this point in time, plea taking may not bar the defense from moving to the High Court for a constitutional interpretation. Decisions of any court higher than this one are binding on this court. I have not heard them indicating to us the prejudice that the suspect will suffer once she takes plea. The office of the DPP will also be bound, is also an office that is bound by decisions of the higher courts. When we were here last before you, the argument by the defense was that the charge sheet presented offended sections of the law that the court has dealt with. So, Your Honor, it is our submission that nothing bars the suspect from taking plea at this point. They can move to the High Court for interpretation of the section of the articles that they indicate. Once the High Court pronounces itself, then this court will comply with those orders. So at this point in time, the suspect is before court. The court has indicated that the charge sheet is proper. So we oppose the application for deferment of plea. That is all.
I'll ask the regulatory report on the issue that you have raised of prejudice.
You know, I take it that the prosecution has not controverted our arguments. Other than subjecting a question to us that we have not indicated the prejudice she suffers, that is on record. She has not urged you to find that you suffer any prejudice whatsoever. And to the best of my knowledge, is that the office of the ODPP is an independent office. They are bound by the decision of the Supreme Court or Superior Court. Yes, but not their decision to charge, because that is independent under Article 157. What we are asking, Your Honor, is within the provision of the Constitution, Article 165, Clause 3D, that the High Court may have the opportunity of determining whether anything said to be done has been done in accordance with the Constitution. And therefore, that's how we shall be invoking the jurisdiction of the High Court. And the same can even be exercised if we were to invoke the supervisory jurisdiction. But we are not asking the High Court to supervise you because you have not made any error. We're not asking the High Court to supervise you. We're asking the opportunity to test whether anything said to be done by the ODPP has been done constitutionally. That's why we're not invoking the supervisory jurisdiction. And as such, our argument, Your Honor, remains uncontroverted. We are most obliged.
So, if I can get you right, you say this, if I allow this, it will be a threat to MP.
I think I'll invite my learned friend who is a political animal to answer that.
Honorable members, yeah?
Yeah, Your Honor, this is very serious, and because this is what you call gathering. Because, as I said in my submission, the role of Parliament is to represent an oversight. You don't represent an oversight in silence. You expound the wishes and aspirations of the people who have voted for you. In fact, it goes to the group norm of the fact that why did you even vote me in the first place if you got me? And that's why we are saying, Your Honor, it is very important that we be allowed to go and make that interpretation. Because what will happen eventually is that if me as a member of Parliament for Gachagua constituency, I'm gagged, you as a magistrate, you're also going to be gagged because of making certain decisions. And therefore, This freedom is not for members of parliament. This freedom is not for the members of the press. This freedom is not for, is for every citizen as guaranteed by Article 3. And therefore, it's very fundamental that we get that opportunity for the good of this country. Thank you.
So I've had your arguments and submissions. So first of all, I'll share with you the ruling on the question of neutrality and the other issues that were shared. And then I'll request you to come on Tuesday next week.
We are most of it.
So in the meantime, I'll extend the bond terms.
We are most of it.
Because I granted their bond terms.
We are most of it.
But one thing I'll want to request, you know, as a court is a hallowed temple of justice.
Yes, sir.
And we would want it to be, we are political
Yes.
as a court.
That's correct. That's why you never said one time.
Yes, so you just see that. So some statements, and I was told, and I take judicial notice, I was told that there were chance of that what you just said there. So I'll just respectfully,
We are most obliged.
with all humility, I think, so that we can maintain the dignity
That's correct.
of this hallowed temple of justice.
That's correct.
Let's not utter such words.
We'll advise you.
Once you're out there at the gate, you can shout the top of your voice there. But once we're within here, let's just, you can sing the national anthem.
We are
told last time you guys, which is quite patriotic.
Yeah.
But some of those utterances or chants, let's just keep it off.
We are grateful and
Yeah,
apologies.
because we want to maintain the dignity of the court.
We are most
Because
obliged.
we're purely apolitical, yeah?
We are most obliged. Yeah.
Because we have to speak for each and everyone.
Absolutely.
Whether you're a member of parliament, whether you're a normal citizen, yeah, we're all equal before the law. So let's just respect that. Let's not, once I leave, I'm sure that, like last time. So
No, you know,
so I've extended our bond terms to Tuesday, the 5th of August.
kindly allow us to convey our apology. That will not happen again. We can allow them to sing the national anthem, but that will not happen again.
Yes, we are trying to we appreciate the extension. Can we request you to give us Wednesday instead of
Wednesday.
instead of Tuesday? There are a number of related cases. Yeah, like another.
So can we agree on the sign?
Okay?
Sorry, I'm corrected by my land friend. I think it's supposed to be the member of parliament. 7. Yes, we are requesting for 7.
At 11, Your Honor.
So 7 at 11. So you will be exact at 11.
We are most obliged.
So I thank you. And also for you understanding it, I was a bit late. My sincere apologies.
It's okay.
But in the evening you get the ruling.
We'll get the ruling by today.
Yes.
By today, so that we can also get back on the other exercise.
Indeed.
Most obliged.
So I still have other matters, so I'll excuse you so that you don't want to stand.
Much obliged.
Much obliged.
The main part is
If you all have been after.
Thank you so much. Please maintain silence. The court is still on.